Hello and welcome to this video about vicarious liability, which you'll find in paper 2 of the AQA A Level law exam. So we're first going to look at when vicarious liability is relevant, and you'll find it in scenario questions in the exam where an employee has committed a tort such as negligence or negligent misstatement, and a person that commits a tort is called a tortfeasor. It's a very wide-ranging doctrine, just means a set of rules, and employers can be liable even for the crimes of employees, and many of the cases are about employees that commit sexual offences, which is actually the tort of trespass to the person, but you will not be examined on those. It's not a standalone tort. It imposes secondary liability, which means you cannot claim vicarious liability, but rather it's a way of making an employer liable to pay damages instead of the employee. It's strict liability and is not linked to fault on the part of the employer. It has been on the move in recent years, meaning that it's changed quite a lot. There's been quite a lot of important decisions, but it's become more settled since the Supreme Court decision in Barry in 2023. There are strong links to policy, public policy, as reasons for imposing vicarious liability, but these would be examined in question 9 or 11 as part of theory of tort law, so they're not going to be covered in this video. So there are three parties in a vicarious liability scenario: the employee who has committed the tort, the employer, and the victim of the negligence or other tort. I've used Morrison Supermarkets here as they've been involved in 2 of the leading cases. So how are we going to spot it in the exam? Because often it's not even mentioned in the question, although in a shorter question it might say with reference to vicarious liability. But in a scenario, you're going to look for the name of an employer who looks like they employ the person who's committed a tort. This might be a limited company, but it isn't necessarily. It could just be an individual, because individuals can be employers. So this is an example scenario from the 2022 paper, and you can just pause the video and have a look to see if you can spot that you would need to do vicarious liability. And I've highlighted here on this slide the things that give you clue. So the mention of movers, who are a local firm of auctioneers who have sent Nikki, and then this paragraph about her working part-time, how they often asked her to visit customers, and the paragraph stating she should only advise on furniture. And then importantly in the question it says Leroy against Nikki, who is the individual, but also Leroy against movers in relation to his loss. So you have to read both the scenario and the question really carefully. So let's have a look at the elements. So an employer can be vicariously liable for a tort if there's a relationship of employment or a relationship akin to employment with the tortfeasor. Akin just means similar to, and the sufficiently close connection test is satisfied. So we're going to have a look now at the meaning of an employee, and here we're looking at whether there is a relationship of employment, a contract of employment, or whether the person is an independent contractor. And sometimes you might find it useful to think of this as someone who is self-employed. Vicarious liability will only apply where there is an employee, a contract of employment. Now the courts have used a number of tests to try and establish whether there is an employee. Traditionally they used the control test, which just is a single factor, how much control the employer has, and obviously the more control you have, the more likely you are to be an employee. And they've also used the integration test, which looks at whether you are fully integrated into a business rather than just being an accessory. And if you were fully integrated, then you would be an employee. However, these traditional cases don't always tell the full story. And so often the courts have used a multiple test, which takes into account a number of factors. This is also called the economic reality test, and it comes from a case called ready mixed concrete. And this established 3 conditions for an employment relationship. So these are the 3 things you'd need to look at in the scenario. Whether the employee has agreed to provide work in return for a wage, whether they accept the work is subject to the employer's control, and you'd need to look at all the other factors that you're told about and make sure that they are consistent with the existence of an employment contract. Note here, it doesn't make any difference whether someone works part-time or full-time, you're still applying these same conditions. So let's see how you would apply it, because when you are applying, you've got to make sure you say which way the factor points. And if there is not much detail in the scenario, you can speculate, and so you can use the word if, which is very useful here. So, being paid. Usually people are paid, but you need to see, are they paid per job, in which case they're more likely to be an independent contractor, or are they paid a salary where they're paid the salary regardless of how much they do. Sometimes that's called regardless of output, in which case they're more likely to be an employee. The second part of the test in terms of control, as we saw above, if you are subject to control, you're more likely to be an employee. Independent contractors will have a lot more control over what they do. And lastly, looking at the other factors. So, for example, if you are provided with a uniform or you are given the tools that you need to carry out the job, then you're likely to be an employee. If there is mutuality of obligation, meaning the employer must offer work and the employee must do it personally, there's more likely to be a relationship of employment. If the employer pays tax and national insurance, then you are more likely to be an employee. If there is nothing on those factors, you can speculate as to what the position would be. So now we'll have a quick look at relationships akin to employment, because the law has extended over the last few years, and this extension carried on in the case of Barry to cover more than just employees. So the 2 most important factors, if you had to apply this in the exam, which is unlikely, is that the tortfeasor was integral to the business and the employee was furthering the aims of the business or organisation. Those originally came from Catholic Child Welfare, but have been now followed in Barry. And examples of a relationship akin to employment have included a prisoner working in a kitchen in a prison in the case of Cox, and an elder in the Jehovah's Witness case of Barry. Note that true independent contractors will not be covered by vicarious liability. So the doctor in Various Claimants and Barclays was found to be an independent contractor as he was paid per medical and he could refuse work. So he was still a true independent contractor. And you'll see that in a number of industries. For example, people like electricians, they have a number of customers, but they're not employed by any of them. They are self-employed and provide services to each of their different customers. So once you've discussed whether someone's an employee or in a relationship akin to employment, you need to move on to the sufficiently close connection test. And you should do this whether you think the person is an independent contractor or an employee, because you need to get the marks for this section. So I would always say, assuming that so-and-so is an employee, then you would look at the close connection test from Various Claimants and Morrison, which was followed in Barry. And that asks if the wrongful conduct was so closely connected with acts that the tortfeasor was authorised to do, even if they did them in an unauthorised or misguided way, that it can fairly and properly be regarded as done in the course of employment. So how would we apply the close connection test? Well, first of all, you need to identify what the employee was authorised to do, and then you need to see if there's a close connection between that and what they did, so that it would be fair and proper to regard it as done in the course of employment. This means that there's going to be liability even if the employee is misusing their position, ignoring specific instructions, or even acting criminally. And the only time where there'll be no vicarious liability is where there is no connection at all between what the employee is authorised to do and what they actually do. And that thing would be considered to be an independent personal venture, or in the language of the old cases we'll look at in a minute, a frolic of their own. So it's quite useful here to consider, is the case more like Mohammed and Morrison, where Morrisons were vicariously liable for the employee hitting a customer at a petrol station? He was furthering the employer's business even though he was misguided. or various claimants, and Morrison, where they were not liable, where an employee leaked data about lots of the employees. He wasn't furthering his employer's business, but involved in a personal vendetta because he had been disciplined by them and he was annoyed. And the personal vendetta is sometimes called an independent personal venture. Once you've looked at whether there is a close connection, it's a good idea to have a look at the traditional cases. In these cases, and the ones we're looking at here are from 1862, 1942 and 1900, you're looking at whether the employee is in the course of employment or on a frolic of their own. So the employer will be liable where work is authorised but it's carried out in an unauthorised way. So in Limpus, the employee was driving a horse-drawn bus, which was what he was authorised to do, but he'd been told not to race it. So when he did race it, he was still doing his work, but in an unauthorised way, and the employer was liable. Or the employee carries out their job in a negligent way. And in Century Insurance, the petrol tanker driver was doing his job by transferring petrol to the petrol station, but he did it negligently as he was smoking and he caused a fire. The only time an employer won't be liable is if the employee is on a frolic of their own. And in Beard, the employee's job was a bus conductor checking tickets, but he actually drove the company's bus and caused an accident. This was outside the course of employment, and he was found to be on a frolic of his own, and the employers were not liable. So my top tip would be, even if you're told not to do something, either orally or in your contract, the employer will still be vicariously liable if the employee is in the course of employment. So this is a scenario question from 2020 in paper 2, and you could just pause and have a little look at this scenario. And you'll note that there are 3 indicative content groups. That just means the content you need to cover. The negligent misstatement, which you would always do first, then vicarious liability, because that's about who will pay the damages, and you need to have established liability for the damages first. And then lastly, the 7-mark part about public policy reasons, why we don't allow claims for pure economic loss. So for the vicarious liability part, you would be able to say that User Art Limited might be vicariously liable for Tina's tort if there's a relationship of employment or a relationship akin to employment and the sufficiently close connection test is satisfied. Now, the most common mistake in this scenario is to say that the fact that she's been told only to value paintings and she values a vase means that User Art are not liable. So here, Tina is authorised to value antiques, and that's what she's doing. So arguably, the wrongful conduct of valuing the vase is closely connected with the authorised act of valuing antiques, and it could fairly and properly be regarded as done in the course of her employment. She's furthering her business, but in a misguided way, like the employee in Mohammed and Morrison. And thinking about the traditional cases, this is like Limpus, where the bus driver was forbidden to race the bus, and when he did race it, he was within the course of employment. She is in the same position. She's doing an authorised act of valuing, but in an unauthorised way by valuing the vase. So that's something to look out for when you're doing scenario questions, and maybe we'll do another video on that another time. So that's the end of the video. Thank you.